5 seconds to go. Start. Suit 4 related to both areas which were attached under section 145 and areas which will clearly note the subject matter of attachment. Consequently, the declaration which was sought in the suit was not merely in respect of the land which fell within the purview of the order of attachment. Relief was sought in terms of a declaration of the property described by the letter ABCD as a public mosque covering both the inner and outer courtyards and the graveyard marked by the letter EFGH, and possession of the area of the mosque depicted as ABCD. In addition, it must be noted that prayer BB was brought in by way of an amendment as a consequence of the destruction of the entire mosque, and the relief which was claimed was as against the statutory receiver, who was appointed as a consequence of the decision in Ismail Faruqi. In view of the above position, it becomes evident that the relief of possession which was sought in terms of prayer B was not only in respect of the area of the property which covered what was attached, but also that which was not the subject matter of the attachment. This being the position, the entire basis of the submission invoking the bar of limitation suffers from a fallacy and cannot be accepted. Reading the plaint, the grievance of the plaintiffs was that they were in possession and had offered prayers till 23rd December 1949. On 23rd December 1949, it is alleged that the Hindus surreptitiously installed idols inside the mosque, as a result of which the mosque was desecrated. By pleading specifically that the plaintiffs were in possession and had offered prayers until a particular date, the sequitur is that after that date the plaintiffs ceased to be in possession. This being the position, it becomes evident that even before the property became custodial legis, following the attachment under section 145, the plaintiffs had been ousted from possession. It was in this background that in prayer A, the plaintiffs sought a declaration in regard to the character of the mosque as a public mosque, and in prayer B, sought possession in case it is necessary. Formulating a prayer for relief in such terms is not unknown to the law of pleadings. Such was the case, for instance, in C. Natarajan versus Asim Bai, where the beliefs were formulated in the following terms. The appellant herein filed a suit against the respondents claiming inter alia for the following reliefs: for declaration of the plaintiff's title to the suit property, for consequential injunction restraining the defendants, their men, agents, servants, etc., from in any manner interfering with the plaintiff's peaceful possession and enjoyment of the suit property. Alternatively, if for any reason this honorable court comes to a conclusion that the plaintiff is out of possession, for recovery of vacant possession of the suit property, directing the defendant to pay the costs of the suit. This court, in proceedings arising out of an application for rejection of a plaint under Order 7, Rule 11 of the CPC, held that a plea in such a form would not invalidate the additional relief. The court observed, if the plaintiff is to be granted a relief of recovery of possession, the suit could be filed within a period of 12 years. It is one thing to say that whether such a relief can be granted or not after the evidence is led by the parties, but it is another thing to say that the plaint is to be rejected on the ground that the same is barred by any law. Stop.